Hey guys, welcome to Southern Law After Hours. Just got done spending some quality time with my big books of illogical and impractically long legal filing names. Why? Well, some of you have mentioned to me on Twitter that some of these recent filings in the Manson cases are just indecipherable. What can they possibly mean? They're long on title and they're short on content. Yeah. $10 boots, $100 shine. Let's see if we can figure it out. You may want to drink for this one. All right, I'm going to look at the first one somebody sent me a picture of, which is order granting sealing application. Let's go right into the fun. With words and phrases so long and convoluted, you'd swear it was in German. Here we have defendants Brian Warner and Marilyn Manson Records, Inc. They filed an unopposed application for leave to file under seal response to plaintiff's motion for review and reconsideration of order denying sanctions. All right, so what does this mean? What is it? Let's break it down. Let's see if we can figure out, start from the beginning, chip off little pieces of it, and see if we can tease out a meaning from this ridiculously lengthy title to a document that is 1 page long and doesn't say anything below it, essentially other than it's so ordered. All right, it's an unopposed application. So what does that mean? That means they're asking the court for something, an application. They're applying for something, and it's unopposed. So it should mean that they've discussed with the other side, I'm going to file this. Can I tell the court that you don't oppose it? All right, that's all that means. So we've got an unopposed application. So this is something that Marilyn Manson wants to do. They discuss with the plaintiff's side, and they go, yeah, we're not going to oppose that. Okay, so the application is for leave to file under seal. That's what they want to do. They want to file something under seal because they need the court's permission to do it. Okay, so remember, in these cases, we've been seeing these confidentiality orders going along. And in fact, in the Bianco case, it was stipulated by the parties and then ordered by the court that certain information could be deemed confidential, and they have to treat it with certain levels of confidence. So one of those things means when you want to file something in court that is confidential or has been designated confidential by the other side, you want to do it under seal. That's not your choice. That's the court's choice. And so you say, hey, court, I've got something that I need to show you. It's been designated confidential, so we want it under seal for now so that it wouldn't be out there in the public if we do present it to you. It won't end up being a court record, but it won't be available to the public. Per your earlier order, that things should be kept under confidence. So far, we've gotten into this a little bit. The unopposed application, plaintiff doesn't care that they do it, for leave to file under seal. What are they filing? They're filing a response to plaintiff's motion. Okay, so here Manson wants to say something about what the plaintiff is doing. The plaintiff's motion. What is the plaintiff's motion? For review and reconsideration of an order. So in other words, they're telling the court, we want you to look again at an order that you recently made, in this case, and reconsider it. We think you missed something, or there's new information, or the law was applied wrong, or something. I don't know. We can't see it because it's all under seal. Whatever. They have some reason to tell the court that you should be reconsidering your order. Now, it can't be just, I don't like the original order that you gave, so there'll be some basis for it, but we don't know what it is. So that's what Manson wants to respond to under seal, and plaintiff's okay if he does it under seal. What's that order? It's the order denying sanctions. So the court issued an order denying sanctions that the plaintiff had requested against the defendants, and the plaintiff wants the court to revisit that. So that's what this is. It's not really anything new. So if you travel back in time a little bit, you remember that Bianco's attorney filed a motion for sanctions against the defendants, but he asked that it be done under seal, and it was allowed under seal, and now this response has been allowed by the court to be filed under seal. So let's see how this plays out on the docket with these long names that don't end up showing you anything, because when you see, which people have now, exhibits that are posted up with these applications are generally blacked out all the way. They're redacted. And then when the permission is given to file under seal, they file an unredacted copy. The other side does get it, of course, but you don't get it because it's in a section of the docket that's kept in confidence from the public. So let's see what's happening on this docket, because when I looked at it, I was trying to look for all these ridiculous filing names, but there are maybe some other developments in there too. Let's take a look. So first, let's go back to just to revisit this. At the end of September, docket entry 70, there's minutes in court, a motion to modify the subpoena, docket 48. So I believe that was the one where Manson had asked that Smithline be compelled to attend the deposition and also asked for costs in that case. So there's minutes about that, but they're not available to the public. This is all you get on that. Then there's some traffic on 71 and 71 that has to do with trying to compel Ashley Walters to comply with her subpoena. If you'll notice, there's a sealed notice of motion and a motion to compel. And we get a little bit heading towards this first document that I showed you in the drama of that on October 14th, when plaintiff Bianco files an application to file a document, motion for review and reconsideration under seal. So she wants to file her motion for reconsideration under seal. So there's going to be something in there that's confidential by at least one of the parties. And then there is a sealed declaration for that. So there's something in confidence in that as well, it looks like. Then the court on the 19th of October says, yeah, we're going to grant that. We're going to grant the unopposed application for leave to file under seal plaintiff's motion for review and reconsideration of order denying motion for sanctions, which, of course, we just looked at the unopposed application to respond to that. So unopposed application, that means Manson didn't oppose her filing the reconsideration motion under seal. Okay, the request for leave to file under seal, it's unopposed by Manson's side. Doesn't mean they don't oppose the revisiting of sanctions. Of course, they do. It just means they don't care that it's filed under seal. Likewise, that courtesy was returned by Bianco and not opposing Manson's request to file under seal. So let's see. So they do grant it, but note it says the court will not convert the proposed sealed document submitted into a new filing. You need to do it. So we will see that coming soon, but the next thing that happens is Manson files his application to file document, response to plaintiff's motion for review and reconsideration, application to file it under seal, sealed declaration in support of that application, blah, blah, blah. Then on the 19th, there is also minutes related to Ashley Walters' subpoena. The court hears oral arguments and the matter is taken under submission. That means the court will issue an order later. So they're stacked up now with the public, at least, not knowing what they decided to do with Smithline's deposition. And they haven't decided yet what to do about the Walters deposition. That's why it's under submission. We kind of only know that they denied the sanctions motion because of the request to reconsider that by Bianco. Let's see where we left off here. That was 77. So 78 is the sealed notice of motion and motion for review and reconsideration. So the court said, you can file it under seal, but you got to do it. We're not going to take your documents and do it for you. Then you notice on 79, which was the 25th of October, this is a transcript order by Marilyn Manson. And when I pulled it up, what it showed was Manson had asked for an expedited transcript of the court proceedings on October 19th. So he wants whatever was said that day in writing in an official transcript, and he wants it in a hurry. Don't know why. Then on the 26th in chambers, it's an order continuing Bianco's motion for review and reconsideration. And the court notes that the plaintiffs sent that motion when they were allowed to file it under seal. They filed it under seal. They filed a notice of motion, so they should have set a date for the motion, and they did, but they set it for Veterans Day, November 11th. So the court says counsel is directed to refer to the motion calendar under this court's procedures and schedules found on the website. Any future motion may be stricken for failing to set it on a date. The court is hearing motions. It was set for a holiday. The court on its own motion moves it from November 11th to December 2nd and says, don't do that again. We might just even strike your motion next time. So that's, pretty good warning there to look at the calendar first. But things happen, and the court went ahead and moved it on its own accord. All right. So then we get a little court reporter action on 81 and 82. Then on the 27th is the docket entry for the document we looked at the beginning of this thing. The order granting defendant's unopposed application for leave to file under seal response to plaintiff's motion for review and reconsideration of order denying sanctions. We all know exactly what that means because we deconstructed it. The task is simply to say it as fast as you can. Shortly thereafter, you see the sealed opposition, resealed notice of motion and motion for review and reconsideration, reorder on motion for leave to file document under seal. And then you see below that transcript order as to plaintiff Esme Bianco, and looked at that, it appears that Bianco also wants a copy of the transcript for October 19th, whatever happened in court. So both parties in this case really interested in getting an official version of whatever was said then. So I think there is some heat occurring in this case, but we just don't know what it is. I have no idea what it is. So there's a little together action there of us working together to decipher a ridiculously long court document title for a document that's only one page long. So that's sad. But what the story is that in all these cases, the confidentiality orders are going to reduce the amount of information that you have, and they'll make the filings more complicated because you can't see the underlying issues that the parties are even talking about. All you get are these multiple filings on the docket of leaves and applications to file, and they're unopposed to file it, but the actual thing is opposed, and it goes back and forth, and it gets kind of confusing. So I understand that. So I saw that on Twitter and told somebody that I would make a short video talking about how to decipher this and what's going on. So not a lot new there, just the parties filing their documents about this reconsideration for sanctions that Bianco's asked for. The only thing kind of interesting to me is the request for this transcript for the 19th, but I don't have any idea what it's for. So I don't know if anything has happened in the Wood case. Gore was supposed to have her deposition, and a protective order was entered just before that, likely to accommodate that deposition. So again, information down, legalese up, and that leads to this. And I hope you guys have a good week.